Morning, everyone. Welcome to our live webinar hosted on Zoom, where we're going to look at some topical commercial contract issues relating to the current COVID-19 crisis. My name is John Farrell, and I'm a partner on the Technology Sourcing and Innovation team here in Mason Hayes and Curran, and I'm joined by my colleague Robert McDonough, who's also a partner on the TSI team. So what we're looking to do is cover a range of issues this morning. So looking at key issues for businesses to consider when negotiating new contracts during the current crisis, what things can arise when carrying out a review of existing contractual arrangements, and particularly where you might want to renegotiate or terminate an existing contract, and then looking at some steps from a legal perspective in terms of exiting unprofitable arrangements or where that arrangement's no longer needed by the business. So just a couple of quick housekeeping points. We're going to try and keep this webinar to a conversational style between myself and Rob. What we're going to do is put up different topics on screen and then explore those issues in a sort of a fairly relaxed form. We're going to also have some broad points up on the slide, but where you'll get a copy of these after the webinar, but it's really just more to keep myself and Rob on track. We also want this to be as practical as possible, so we'll leave plenty of time at the end to pick up on some of your questions. So if you do have any questions as we're going through, please put them into the Q&A box and we'll get to as many of these as we can. Okay, so that's probably a good point to move on to our first topic. So what changes are you seeing from companies that are in the middle of starting contract negotiations? So probably a good opportunity to hand over to my co-presenter, Rob McDonough, and maybe Rob, you can take the first points here.
Yeah, no, John, thanks very much. I'm glad to be here with you. I think you're in San Francisco, is it?
Yeah, I'm off site here. You know, the cabin fever was getting a bit too real.
Good to see you're obeying the government restrictions. Anyway, so moving on swiftly. So yeah, look, I think one of the first things that we're seeing with companies that are in the middle of negotiations or are actually starting negotiations is they're just really doing that increased focus on due diligence on the supplier. And that's because, you know, a supplier who may have been doing well and might have been, you know, a very kind of reliable supplier up until now is obviously facing very different circumstances. So we're seeing a real significant emphasis on due diligence on suppliers. They're looking at things, you know, obviously the old things like track record and, you know, their balance sheet's going to be important. But we need to look forward as well and what's the immediate impact. So, you know, obviously a focus on solvency, sometimes looking for or trying to get access to projections, looking at how their customer base is interacting, because a lot of companies are hoarding money or starting to hoard money now. That's going to impact on suppliers, because if all their customers aren't paying them, they may run into solvency issues. Also, a real focus is not just on the supplier itself, but its supply chains, because a number of suppliers might be very reliant on other subcontractors, and the supplier itself may be in a strong position as a prime contractor. But if its key subcontractors are in difficulty, well, it's going to ultimately encounter the same difficulties in supplying. So we're seeing a focus on due diligence around the supplier and also some risk mitigation measures. So for example, instead of putting everything out with a single supplier, they might go with a dual sourcing or even a broader tri-sourcing solution to try and mitigate the risks around those suppliers.
Yeah.
What kind of stuff are you seeing on that, John?
Yeah, I think like it's really difficult at the moment to try and, you know, do that due diligence on suppliers. You know, the sort of the old metrics of, you know, looking at balance sheets and annual returns and things like that. You know, we're just in such an uncertain time that even those type of things don't give the level of certainty that they used to. So it's really difficult to do that pre-contract due diligence on companies. And I think I'm even seeing some companies start looking at things like, you know, where is the counterparty group located, or where is it headquartered? You know, and what sort of business supports is the government of that country offering? So, you know, if you take like the cruise industry as an example, they're under a lot of pressure at the moment, because even though they're these massive companies and they have huge footprints in many countries, including the US, because a lot of them are headquartered offshore in the likes of Bermuda, they're not being able to avail of a lot of these early government support schemes. So they're having to go out to the markets and try and raise cash. So a lot of that sort of stuff, you kind of have to start thinking outside the box a little bit. And I think even on some of those things you mentioned, like parent company guarantees and things like that, you sort of need to approach them a little bit more caution than you may have before.
Yeah, no, I think so. And what you see then is that diligence and that risk mitigation strategy, you see that flowing into the contract. So there's those normal battlegrounds like liability and so forth, but actually a number of these concerns that customers have around their suppliers or suppliers have around their own supply chain flow into the contractual negotiations. So for example, you might see, warranties around the solvency and projected solvency of an entity. Obviously, suppliers are pushing back on those and making them quite heavily caveated. Financial distress reporting obligations, mitigation measures if a company falls into financial distress, suppliers looking for, backups on the customer's payment obligations, customers looking for backup, whether from within the group or outside the group for the supply obligations. So you're seeing a lot of stuff, that diligence and the risk mitigation flowing down into the contractual provisions. What other things are you seeing there around the contract?
I think risk mitigation is absolutely the number one priority for people entering into contracts at the moment. I think, the sort of all reliable battlegrounds, things like liability, there's still going to be a focus. But really it's sort of anticipating that something's going to go wrong in the contract and looking at those things like, dispute resolution and escalation and try and mitigate risk. I think also sort of is a great time for boilerplate clauses. I think people are spending more time negotiating things like force majeure clauses than they ever would have before. And I think a lot of other areas which usually, 6 months, 12 months ago would have been agreed pretty easily are being much more difficult negotiating areas now. So if you take something like retention of title, so, what a retention of title clause does is it retains the ownership. So if you're a supplier and you have retention of title, it'll maintain your ownership of the product even after it's delivered to a customer. It becomes very important in insolvency type scenarios, where you're sort of delivering without getting paid on delivery. They've always been there in those supply of goods agreements, but there's a lot more focus on them now, and there's a lot of things that can go wrong. We've probably all seen negotiated contracts or heard stories where retention of title can cause difficulties, but it's one of those areas that you won't realize you've done something wrong until actually you go and try and enforce it. So it's kind of practical look at it as well. You need to really analyze what are the business operations of the customer. Are they taking your products and mixing them with others, or are they keeping them separate? Like, a lot of those things will have really important impacts. And
the tie-in you see to that, John, and I think we were discussing this earlier, was the whole payment regime and where that falls. Because if you get payment early, obviously you don't need to retain title. But if payment is quite late, well, then you do need to have that retention of title, and there's a real focus on it. And similarly, the customer, I think on the other side of that, John, I think the other point we were discussing was customers are reluctant to make payments early, and they're looking to delay payment as much as they can. Whereas, of course, the supplier wants payment as early as they can, and looking at the timing of payment, milestones, any security for payment, whether that's escrow, letters of credit, or other mechanisms, have really become a focal point.
Yeah. One thing I'm seeing a lot of reluctance, particularly on the customer side, is around things like exclusive purchase obligations. And I think you touched on it in a couple of your earlier points around things like dual outsourcing. They're really, anybody who's sort of going out to market with big outsourcing projects at the moment, they're really looking at dual outsourcing where, or even more than that, where you'll have multiple potential suppliers. And really, again, it goes back to that idea of risk mitigation, where you're almost anticipating things going wrong. And, if you think about some of those big outsourcings, like, the reality is, they take months sometimes to actually implement. So, if your supplier fails, you're not going to, get another one in the next day. So I think that's what we're going to see a lot over the next 12 months, those kind of multi-party outsourcing arrangements.
Yeah. Yeah, and I suppose maybe just before we move on, just one final point around this is because the kind of exclusivity element, you can still move forward with a big outsourcing because you may want to do so. But if there is an exclusivity element of it, sometimes what you're seeing is a negotiation where the exclusivity falls away in certain circumstances where they're not maybe hitting all obligations.
Yeah.
And then there's other things that I think particularly are becoming important are just escalation, termination. Some customers looking for prioritization obligations. That's an obligation on the supplier to prioritize its obligations under a particular contract to meet those obligations. So customers like them, I'm not sure how much real impact they have in practice. If a supplier is not doing well, it's not doing well, and the prioritization clause may not make a significant difference. But some customers do take some comfort from them.
Yeah. Okay. Well, look, I think we might move on to the next topic. So, force majeure. This sort of been like Brexit clauses over the last few weeks. I don't think there's ever been as many articles or webinars and talks about the impact of force majeure on your contracts. But I suppose just, not to labor on it again, but I think there's still a lot of confusion. That's probably fair to say, isn't it, Rob? That like a lot of people are still misinterpreting what the force majeure is going to actually do for you. Like, I guess the first most important point is force majeure is a creature of contract. It doesn't have a basis in common law. So, I've certainly had queries, and you probably have as well. People talking about how do we imply a force majeure clause into our agreement and things like that. Like, the reality is, if you don't have the force majeure when you sign the contract in it, you're not going to be able to imply it in after the event. You're probably looking at something like doctrine or frustration, which obviously is much more difficult to rely on.
No, you're spot on. But and one thing that some people kind of forget, though, is if your contract's governed by Irish law, governed by UK law, we're dealing with common law. But actually, in other jurisdictions, there are doctrines of frustration or of force majeure, like in France, for example. So you need to actually look at the governing law of the contract as well when looking at this. But like, assuming you're dealing with an Irish contract, you need to really just focus on what the contract says. So maybe we move on to that next slide, John.
Yeah. So what we thought would be useful is just to put up a fairly comprehensive sort of standard enough force majeure clause, just to kind of talk you through a couple of the real points to focus in on if you find that you're having to look at one of these clauses. I think, look, just as a really general point at the start before we dive into the specific underlined points, I think it's really important to bear in mind what a force majeure clause is actually going to do for you and your contractual obligations. It doesn't act as an alternative termination right in most instances. It's all about, a party is prevented from complying with their obligations and, giving relief for that, as opposed to getting out of what might be an unprofitable or more difficult to perform contract. So look, I think the first thing to focus on when you're trying to look at one of these clauses is what way is force majeure event actually defined? And you see, this is a pretty broad definition. So it talks about circumstances that are not within a party's reasonable control. And then this definition includes, without limitation, different types. And you see epidemic or pandemic is underlined there. And this is something we've seen come into contracts after the first SARS outbreak many years ago. So most contracts will include something like this, but not all, and particularly older contracts won't have it. The real focus on it is the impact of that force majeure event on your obligations. And that's probably the most important thing to look at, isn't it, Rob?
Yeah, it's exactly as you said. Like, first of all, you identify, is there a force majeure event? So you look at the definition. Sometimes it's going to be really clear. So it'll say epidemic or pandemic. Sometimes it won't be so clear, but you might still potentially be covered. Sometimes you see things like material shortage of raw materials, compliance with the governmental order or rule that could be relevant, embargoes. So there's lots of things there that you need to look at. But once you've satisfied that there is a force majeure event, if it's actually not impacting on you to the threshold set out in the contract, you're not going to be entitled to any relief under the contract. So you need to look quite carefully at what the contract says. So in this case, it says, if you're prevented, hindered, or delayed from performing your obligations by a force majeure event. That's a really broad spectrum there. Prevented, hindered, or delayed. But sometimes it'll actually be much more limited, and it might just be prevented, or to say you cannot perform due to force majeure, in which case, you know, it's a much higher threshold you have to satisfy to be able to actually rely on the force majeure. And there's some other elements you'll see here, like at the start of clause 1.2 there, you'll see it says, provided it has complied with clause 1.3. And this is something that's pretty common within force majeure clauses. To be able to get relief, one, you need a force majeure event. Two, it needs to have met the threshold for impact upon you. But three, and significantly, you have to have complied with the process set out in the force majeure clause. Maybe, John, you might want to touch on that a little bit, if you don't mind.
I think like this is probably the most important part, and the thing that gets overlooked a lot. You know, people think, well, I have a force majeure provision in my contract, I'm okay if I don't perform. The reality is there will always be a procedure which you need to invoke to you know, implement or give effect to the force majeure provision. So I think, you know, it'll always be something like this. You know, if you look at 1.3 there, as soon as reasonably practical after the start of the force majeure event, but no later than a certain amount of days after you start becoming affected. So you could actually lose your ability to rely on force majeure if you don't act quickly enough. You'll see there's also typically obligations to use all reasonable endeavours, which is a pretty high standard from a legal perspective, to try and mitigate the effect of force majeure. So there's a lot of nuances around how force majeure will operate in practice, and it's really easy to kind of take the wrong path. And from just a pure strategy perspective, if you're a party that's struggling to perform your obligations under the contract, you need to think about when you pull the trigger for force majeure, because, you know, once you sort of notify that force majeure event, you start the clock running. If you look at 1.5, on potentially the other party having an ability to terminate, unless you can kind of bring yourself out of the force majeure event. I don't know what your experience is, Rob, but like most clauses I see tends to be that one way sort of scenario where it's only the non-force majeure event suffering party that has the termination right. I know you can see sometimes people relying on their own force majeure to terminate, but it's more unusual, isn't it?
It is, but I have to say I've snuck it in once or twice.
Yeah, well, look, that goes back to if you're entering the contract now, you know, it's definitely something to think about because it can be really useful, you know, if you're not really getting much movement on termination rights.
Yeah.
Okay. Yeah, so I suppose, look, we've kind of talked through the clause. There's a couple of kind of the takeaway points on it. I think, look, my biggest takeaway, I'll let you kind of wrap up in a second, Rob, but my biggest takeaway is just really understand what your force majeure clause says, and kind of be ready to run with it when needed. They're going to vary a lot in different contracts, so you just really need to be careful and know what you need to do.
Yeah, no, that's it. And the thing is, you know, be careful what you wish for. So don't invoke it unless you think you really need to. But if you do, then make sure you've served the notice, you follow the process. There could be a dispute about this right now or later. So document the impact the force majeure event has had on you, what measures you've taken to overcome it. If you reach any agreement with your counterparty, document that as well. Always thinking about disputes in the future. Remember, if you're the innocent party, you have a mitigation obligation. Look at changes in circumstances, because you might be impacted today, but maybe not necessarily impacted tomorrow, and vice versa. So there's lots of different things you need to look in and take into account there.
Absolutely.
And also just to remember, you know, change in law clauses, material versus change clauses, there may be other relief events within a contract that aren't limited to force majeure, so it's worth looking at those too.
Absolutely. Okay, I think we've probably all had enough force majeure for the moment. Let's move on to the next topic. What steps are we seeing companies take to manage their existing contracts? And I think this is a process. Certainly, I'm working with a lot of clients at the moment. You know, looking at what's there in terms of your existing contractual obligations. And I suppose there's sort of two main buckets. You know, you have those contracts which are business critical, or which, you know, obligations might be triggered because of something that's happened from the COVID-19 crisis. And then there's also those contracts that are just not profitable, or which, you know, aren't needed for the business at the moment. You know, offices are closed, so you know, people are obviously trying to protect cash flow as much as possible. So I think, look, this is primarily, in my experience, a business-driven process initially. So the business needs to look through the contracts, needs to see, you know, what are the business critical ones, what are the ones, you know, ideally we want to either renegotiate or try and exit. So I think that's first step. Once you have that, you need to distinguish where you are in the supply chain. You know, so you can be a purchaser, you can be a supplier, or even a supplier within the chain. Isn't that right, Rob?
Yeah, exactly. So if you look at yourself in the supply chain, you're either going to be the customer, so you're buying something, but you may not be the end customer because you might be buying something to onward sell. So as a part of your onward upstream supply obligation. So we've been working with some clients around this and looking at, well, how do we look at all these contracts we have? And when you're the purchaser, you're looking at it in the context of, is this business critical? So is it important to keep the lights on? Or is it important so we can meet our upstream supply obligations? And then when you're the supplier, so you're looking at the context of where you have an upstream supply obligation, is this contract materially problematic to you? Is that for practical reasons because you just can't meet the supply obligations? Or commercially, you're able to meet them, but the cost of the workarounds in the current environment are just making the contract loss-making or just commercially not viable. So looking to distinguish between those two. And then also when you're a supplier, so you also need to look at, well, have you any particular obligations that have been triggered in this contract by virtue of the current circumstances that you need to comply with? And once you've done that, you're trying to come up with a strategy. And
sorry,
I'll touch on that there.
Yeah, sorry, I've just I fat fingered it and moved on the slides, but probably good to keep us on track. Yeah, so look, I think, you know, once you kind of separate out the purchaser and I guess the supply side, you know, when you're talking about business critical contracts, you know, what are the things you'll typically go to and in your contract to try and look for, or you know, you think people should try and focus on?
Yeah, when you're looking to devise your strategy about how to deal with the contracts, you need to look at a couple of things. First of all, you know, this is something you're buying in and it's business critical. You need to look at the supplier and just get an understanding of the facts on the ground. What's his status? Is he solvent? Is he having supply issues himself? What's the status of his supply chain? What's his credit line? So you start to engage with the supplier and ascertain the factual matrix, because it's really important to know what's going on the ground. And then you're also going to want to look at the contractual side of things. So what's your contract say? Does the supplier have business service continuity obligations? Is it complying with them? Is it entitled to contractual relief? So force majeure, is it getting legislative relief or benefits under its country of establishment? What rights do you have? Do you have a right of step in, for example? Can you increase your orders? Is there, you know, are you about to put in a new forecast for orders? Should you be downsizing or upsizing that? And then looking at things like, where's your leverage? So, you know, when's the next payment due? When's the next delivery due? So the number of different factors that you want to factor in looking at a contract under which you're purchasing services or goods and helping you to devise a strategy to deal with it, and look at whether ultimately this is something where you need to look to someone else, you need to look to the existing supplier, and you need to leverage the provisions in the existing contract or any other practical leverage that you have.
Yeah, absolutely. And like, I think ultimately, you know, when you're on the supply side, it's a similar enough task in some ways. You're seeing where you fit into the flow, but it's fair to say, like, it can be a lot trickier on the supply side, because you might be just one link in the chain. You know, you have obligations to your end customer, but you might have subcontractors or sub suppliers, and you know, you could be relying on raw materials or somebody else providing services, and you kind of need to marry everything together to make sure you're not left exposed. So, I mean, is it the same sort of task on the supply side? You know, what are you kind of looking for there?
Yeah, no, it's similar. I suppose like the outcome here is, look, you're either going to want to try and exit from that contract or suspend the performance of it some way or renegotiate. And I think what's important around all this is, one, when you're engaging, whether it's a customer or a supplier, you know, you want to engage with a view to a long-term partnership. But at the same time, when you engage with people, you need to remember that things may become contentious and have that in the back of your mind. So when it comes to looking at your contract, you're looking at, well, what specific obligations have been triggered? And then also just looking at, and there are things like, for example, business service continuity. Do you have FM reporting obligations? Early warning? Has the remedial plan process been invoked? Do you have one of those prioritization obligations? Financial distress reporting obligations? Are you now in breach of any of your ongoing warranties regarding solvency? But also, John, if you just slip back to that previous slide, if you don't mind for a second. Yeah, you also want to look at, well, what kind of leverage do you have? So what entitlements do you have for relief? Is the contract just about to expire? Is it about to auto-renew? Can you stop it auto-renewing? Do you have a termination or suspension right? And looking to leverage, not just off those legal pieces of legal entitlements that you may have, but also the practical ones like the dependency that the customer has on you, and looking to come together to find an appropriate strategy to get yourself out of and manage this difficult contract. And an important point in that is obviously going to be your liability. So have a look at that liability clause. Does it deal with deliberate breach or deliberate abandonment? Is that carved out? Often it is unlimited liability. If not, maybe you can argue that you still have a cap on liability, but certainly the position is unsure.
Yeah. Yeah. And I think, look, I think a lot of this stuff, I think we're really in the mindset, or certainly a lot of businesses are, that, we're going to see a lot of disputes and litigation. I think that's just probably inevitable, over the next 6 to 12 months, maybe even a little bit longer, as a lot of these things kind of shake out from contractual arrangements. So I think it's really important that no matter what your engagements are or your dealings with suppliers or customers, to make sure you kind of do things in accordance with what the contract's saying. You're following procedures, timelines, because all that sort of stuff is going to stand to you ultimately if you do get into a contentious scenario. Okay, so we just might move on then to the next topic, and I suppose we looked at the kind of the business critical side. What if the sort of non-business critical or the contracts that are just no longer profitable, or that the business just doesn't need, and you're trying to trim costs and maintain cash as much as possible? What sort of approach do you take here when you've identified those contracts? So look, I think, again, this is going to be driven by the business team. They're the ones who are going to come with these lists of contracts that are just, you either want to terminate or renegotiate. And I suppose just to focus on the renegotiation bit first. Again, go back to something you mentioned earlier on, Rob, the idea of leverage, so it's looking at the contract, seeing what leverage you have to try and, force through amendments or changes to the existing commercial terms. And some things I'm starting to see being used as leverage. If you're a customer and your supplier, it's near the end of the term, offering a longer term, for better financial provisions, that's something that's been used as leverage. If there's good termination rights in the contract, if somebody be entitled to relief under the contract, a lot of that stuff, and it could be even just what you're looking for is changed payment terms, and even on the customer side, offering some cash up front or sort of front loading some of the payment obligations. That's something that can get you really good deals in terms of the rest of the contract. What else are you seeing in terms of people looking at trying to renegotiate in contracts at the moment?
Yeah, I think it's kind of like you said, John. You're looking at the leverage that you have. You're looking at the goodwill. You're looking at the dependency that the customer has on you, and really you're just trying to work with the customer to come up with something that works for both parties. And because ultimately we are all in this together, and you need to take a pragmatic approach to this. And I think both parties do. And I think you need to approach engagement with your counterparty with that in mind, because it's all well and good jumping up and down, but ultimately, if your supplier has absolutely, insurmountable difficulties, jumping up and down is not going to make a huge amount of difference. And what you want is you want to keep the lights on in the meantime, or to perform your obligations upstream. So it's just looking to partner as much as you can, and exercise the leverage that you have insofar as you can do so. And I think, one thing that actually you just need to be really conscious of in all of this is, don't make short-term decisions that have long-term implications without having carefully thought that through. And if you want to maintain certain contracts, terminating them isn't the right way out. And saying things that may trigger termination rights isn't the right way. So sometimes, threatening to cease supply is actually a termination trigger under a contract. So you need to be very careful around how you engage with counterparties.
Absolutely. And that's a great segue into the next topic is, what are the pitfalls and options when you're looking to amend contracts? So you've agreed, revised commercial terms. How do you do it? Well, look, I think in the current climate, there's two goals you should have in mind. You want to do something that's quick, and you want to do something that's economical. Nobody wants protracted negotiations or amendments. At the moment, there's lots of other things to be focusing on. Again, going back to those, rarely loved boilerplate clauses, I think your first port of call here should be your variation clause. Most contracts will contain something, but the current crisis has actually given rise to lots of really unforeseen difficulties around this, and notices is another one that we'll come to when we're talking about termination. But even practical things like who's authorized to sign amendments under the contract. How do they have to be signed? Do they have to be signed in person? Can you do it sort of by electronic signature? A lot of those things are actually going to be really important and could have a big impact on how you get these things signed. And to touch on something you mentioned earlier on, this kind of long-term view, I think it's really important, and something I'm saying a lot to clients. If you have a 4 or 5 year contract, like you need to get something changed now, and that's fine. But this will pass. 2, even 3 years down the line, whatever you agree now is going to become part of your contract. You won't have that ability to go and unilaterally bring yourself back to whatever the initial position was. So what I'm seeing a lot of things getting put into contracts is this idea of a sort of a release valve where, these provisions will apply for a certain period of time, but after that, they either need to be renegotiated and extended, or something else agreed, or it'll revert back to the previous position. And it just gives that little bit more flexibility. I think it's really important to take a really mechanical approach. And I know from drafting contracts with you, Rob, that this idea of fitting everything together like a jigsaw and making sure it all lines up, you're a big advocate of that.
Yeah, no, I am. Thank you, John. But no, in fairness, it is important that you get things right and that you think things through, and that ultimately it does all join together. And I think some people, really rushed into certain initial decisions and perhaps are looking back now and saying maybe we should have taken a more measured approach. And that comes to things like invoking force majeure. It comes to making changes to contracts. And so you just need to take quite a methodical and cautious approach. We need to get things done quickly, but we don't want to do things badly. So taking your time to do it right is definitely appropriate. And bearing in mind always that, we do want to partner, but that's not always going to work out, and things can get litigious. Yeah.
Okay, I think that's a nice passage into then the final topic we want to talk about, which is, you've just decided it's just not commercially viable for one reason or another. There's no point renegotiating. You just want to exit. You want to terminate. What should you be focusing on in the contract? Well, look, I think definitely first thing to look at is the actual termination provisions. And, there's lots of potential options in here. I guess I'll kick off with the first one, termination for convenience. That's probably going to be your first port of call. Do you have an ability just to pull the plug and say, we're going to give you a couple of months notice, and the contract is going to end? And I think that's probably the easiest route. But there's lots of kind of hidden pitfalls to think about there as well. So you need to make sure you're not triggering anything like a termination payment. You also need to think about the notice periods you need to give. It could be a fairly long notice period, so you just need to bear that in mind. Termination for insolvency, probably doesn't get much love in contract negotiation sort of pre-2020, but I'm certainly seeing a lot more action in terms of getting pushback on clauses and indeed making pushback myself. What are you seeing, Rob, in terms of termination for insolvency? Are you seeing anything weird or unusual coming in?
Yeah, I think people are just trying, look, I suppose you're looking at it in two contexts. One, forward looking, and two, just looking at some current contracts and looking at whether you can actually terminate at the moment. And certainly at the moment, some people have been exploring whether, whether certain actions that people are taking constitute an insolvency event. So like I said earlier, sometimes you see quite a broad definition, and it includes things like a threaten to cease to perform, or it can include, declaration of inability to pay. People looking at whether calling on, governmental supports indicates an insolvency event. So I think, look, it's obviously going to depend on the contract, but people have been a little bit, they've been what would be the word you would use? Inventive in coming up with ways to look at this. But ultimately, the decision, and this is the key thing actually with any decision to terminate, is if you get it wrong, that's technically a repudiatory breach. So the other party can sue you for damages. So you need to be really careful and confident in your position if you're going to try and terminate. And, the contract might leave a little bit of a gap, but if you push that gap too far and you get it wrong, there can be really significant consequences.
Yeah, it's definitely something to bear in mind, that kind of sort of aggressive termination approach where you're kind of skating on thin ice. I think, outside of that insolvency scenario where you're sort of trying to come up with inventive things, another one to look at is, what does the contract say around things like material breach and terminations for poor performance. If somebody's not performing under the contract and they can't rely on force majeure and they have that obligation, then, you tend to have shorter termination periods in there, the notice periods, than you would for something like termination for convenience. So it's definitely worth looking at. One particular thing I wanted to touch through, I suppose, we've been talking about the ideal contractual scenario up until now, where there's a really detailed and well drafted termination clause. But we've all seen contracts where it may have been initially for a fixed term, but it's long since expired, but the parties are still performing. It may be a scenario where there was never a contract put in place. I think what's important to bear in mind on that is, look, common law, certainly from an Irish and the English law perspective, is not going to bind you into perpetual contracts. Even if there isn't a termination right there, people won't be locked into contracts forever. So you'll still have that termination ability, but what you need to bear in mind is this idea of providing reasonable notice, which tends to be what the courts will apply in. And, that's kind of like, how long is a length of string? What's reasonable notice in the scenario? Like, I've looked at this issue for clients a few times over the years, and it really depends on, how long has the contract been in place? What type of industry is it? What will be the industry norm? Lots of issues like that is what the courts will tend to look at. But I think it's, there is an exit out of it, but you just need to tread carefully. One other thing I just wanted to touch on again is the idea of the boilerplate clause. And another really important one here is the notices clause. And to go back to something you mentioned a few minutes ago, Rob, around the idea of getting this wrong and potentially it being a repudiatory breach and opening yourself up to damages. This idea of making sure you comply with what the contract says on the notices. Who do you have to deliver the notice to? What form does the notice take? If you can only have notices by post, but the counterparty's offices are closed, as most offices are at the moment, how do you manage that? So, like, there's lots of tricky aspects to it that you need to think about and make sure you have kind of lined up correctly. And then, look, once you actually do terminate, you need to think of the exit management, and, lots of things can arise there. TUPE is one, for example, Rob, isn't it? That, you need to just make sure it's kind of go back to something you mentioned, be careful what you wish for.
Yeah, well, I think that's a good point. You know, like if you terminate a supplier, it may be the case that you end up having all their staff transferring to you under 2P, or that they may need to transfer to a replacement supplier who may not be willing to take them on, and that may create difficulties for you. And the other thing to think about with 2P is just that, you know, often when a supplier is coming to a position where they're about to, like the contract is about to be terminated, they might start to move the good people off the contract and move the bad people in. So the people who actually do transfer through 2P are the not so good people, or the people that you know, want to get rid of, as the supplier wants to get rid of. And so, you know, often a contract will actually regulate that quite carefully, and it'll have provisions restricting the movement of people within a notice period, or, you know, or a pending notice period. But it's just something, I think 2P is just something to be conscious of if you are in that position where you're looking at potentially terminating some contracts.
Yeah. Okay, well, look, I think that kind of wraps up all the sort of big topics we wanted to talk about. So we might maybe just delve into the Q&A a little bit and pull out a couple of questions. I still think we have a few minutes left. So I'm just going to pull up the chat box here.
Okay, so I've got one here, John, that I'll take. So what happens if the other party just ignores the contract and refuses to pay? So I guess this is probably from the supplier perspective, and the customer is just refusing to pay. Like, ultimately, in a situation like this, the fact, first of all, that the customer has refused to pay suggests either A, it's in difficulty and it's not paying for that reason, or B, it's making a strategic decision to hoard cash, and it's doing so across all of its contracts. And so in that situation, you know, in legal terms, the position is kind of clear. If they have an obligation to pay, the payment isn't in dispute, then contractually they have to pay, and you're entitled to sue them for damages, to sue them for payment, including interest for late payment. But I suppose, you know, in taking that decision, you obviously need to tread carefully, because is that the best outcome for you? Perhaps you might want to partner with the supplier or with the customer through this difficult period, if you can do so. And maybe in that case, it might be worth saying to them, look, we appreciate you're in difficulty. Can you make 80% of the payment now and 20% later? Or can you come up with some kind of solution that's going to work for both parties, rather than jumping straight into a legal dispute? But ultimately, if they don't pay, you know, you're going to be entitled to sue for payment. And the problem there, I guess, is, do you get in quick enough? If they are really in difficulty, you know, ultimately you're going to be an unsecured creditor, just like
and that's where, go back to what I mentioned earlier on around retention of title. You know, if you're the supplier and you have goods out on site, you know, you may not ever see your money for those goods. But if you can get the goods back, that's obviously the best of a really bad scenario, you know.
Yeah, no, obviously that's a good point, yeah.
So I see a couple of questions of force majeure here, and one I'm just picking out is the force majeure concept in other jurisdictions, and we sort of touched on this briefly. The example here was Belgium. You know, so I think it's a really good point, and it's worth emphasising again that you made earlier on. So, you know, Irish law and English law doesn't have this idea of a sort of an implied force majeure obligation into contracts. You either have it in your contract or you don't. If you don't have it, that's, you know, not necessarily the end of the story. There could be other reliefs, or if you're trying to rely on sort of implied common law principles, there are things like, you know, potentially the doctrine of frustration. It's really hard to apply that in practice. It's just a really high bar. But the question is, you know, is this a kind of a standard position throughout Europe? And I think, look, obviously we're not French or Belgian lawyers, but I think, you know, you mentioned earlier, Rob, and I've seen it a couple of times before as well, that, you know, some civil law countries do have this idea of implied force majeure provisions, which can override, you know, clauses that are in the contract. Sorry, you may hear dog barking in the background. My dog's having his daily battle with the postman, so apologies for the slight interruption. Or maybe he just doesn't like force majeure as a concept, who knows. But yeah, I think, look, the takeaway is it's not a common position throughout Europe. That's a real common law position, that there is no implied force majeure. But definitely if your contract's governed by civil law, it's worth exploring, because some countries will have that implied concept of force majeure.
Okay, just another one here. If notice on the contract is to be served by post and the company's office and COSEC's office are closed, what do you suggest is done in the alternative? Well, I think the first thing is, post is still working here. So, comply with the contractual provisions for services of notice as best you can. That's the first thing you want to do. And then you want to take any practical measures you can on top of that. So, for example, you might want to send a scanned copy by email to the relevant party, unless the contract actually allows for service of notice by email also. And it's worth bearing in mind that the concept of writing is defined in the Interpretation Act to essentially include email, although sometimes boilerplates take the opposite approach and they exclude email from the concept of writing. But so what I would be doing is I'd be trying to follow the contract as best I can, serving notice. Secondly, I would be emailing it. And thirdly, I would probably be ringing the person and taking a memo of the fact that I have told them that notice has been served on them. So basically what you're trying to do is you're trying to build up a chain of evidence to show that you have done absolutely everything you can do to follow the process in the contract and in practical terms to bring it to the attention of the relevant counterparty.
Yeah, I see some
somebody. Sorry, I have to mention this comment. Maybe the postman is delivering a notice of termination.
That's the contract. Well, look, I'm glad people are keeping their sense of humour. My woes with live webinar recording. There was a question here around insurance, and actually it just caught my eye because I meant to mention it when we were chatting through it. I think insurance are a really interesting one. So the question is, are insurers paying out for breaches of contract during the crisis? Like the point I wanted to make on this, and I think it kind of goes to this question as well. I think, hopefully I'm not insulting any insurance companies on the call, but look, they're not in the business of really paying out claims unless that's what's in the scope of the policy. So, anything with insurance where you're trying to rely on another party's insurance, obviously it's a level of comfort. If they don't have the cash, that may foot the bill. But I think I treat a lot of that warily and with caution at the moment. And I think particularly if you're looking at entering into any contracts now, and you're including your insurance clause, I definitely be trying to have a look at the insurance policy if I can, or get comfort that, COVID-19 related issues and other pandemic type issues are covered within the contract. Because if they're not, it kind of doesn't really matter what your contract's going to say. It's, if the insurer is not going to pay out the counterparty, then it's not really any benefit to you.
Yeah. And that's one of the things people I think are focusing on a little bit now at the moment. Okay, so one of the other questions there was just to flesh out frustration, which is something we'd meant to do earlier, but we were just trying to kind of keep a bit of progress through the slides. So just at a high level, frustration is pretty hard to achieve, the doctrine of frustration. If a contract is frustrated, it's actually frustrated automatically, and it stops ongoing obligations, but it doesn't impact on obligations performed up to date. So when's it available? It's available if due to something that wasn't foreseen, performance is impossible, or has become fundamentally different to what was envisaged. One of the difficulties that you often have is if there's a force majeure clause, that may show that the parties have foreseen the circumstance. And particularly where it can get a little bit complicated is, what if the force majeure clause only operates in favor of one party, but it's the other party who's impacted by the current crisis? But in that circumstance, there's probably a reasonable argument to say that frustration isn't available because the circumstance was foreseen. The parties just commercially agreed not to give relief to one of the parties in respect of that circumstance. One of the other points around frustration is that, sorry, actually I've lost my train of thought. Is there anything you want to add on frustration there, John?
Yeah, I think, look, I think if I was in a scenario where I needed to try and rely on frustration, I'm probably in bad shape. I think when you look at the cases on it and a lot of the, what people the academics are saying about it, like we'll need to see some cases come out to see what the scope of it is in the current crisis. I think like even with SARS and swine flu and things like that, we've never seen a crisis like this. So it may tip over into frustration.
And there wasn't really much successful outcomes in trying to rely upon SARS
No.
in the context of frustration. So
yeah, I think like the biggest thing for me with frustration, and kind of my general rule of thumb what it is, it almost needs to make the contract impossible to perform. So, you know, just because the contract is more expensive or even an awful lot more expensive or more difficult to perform, that doesn't mean it's frustrated. You know, it's almost getting close to something like it's actually impossible to perform. So, you know, you have a contract for something to be delivered on a specific ship. That ship sinks. You know, and like frustration was something that was tried a lot. A lot of the big English law cases on this revolved around the Suez Canal crisis, where, you know, it made contracts, you know, 10, 100 times more expensive to perform, because instead of going to Suez Canal, you have to go around the coast of Africa. That wasn't held to be high enough to constitute frustration, because you could still perform. It was just a lot more expensive. So I think that's something definitely to bear in mind, that you're probably in bad shape if you're relying on frustration. I might just take one more quick question, because I see a couple of things around the scope of force majeure and you know, have you seen force majeure being relied upon in the context of reasonable notice and contractual time periods for things such as compliance with audits? So I think the important thing to keep in mind with force majeure is if you're relying on it, typically it will absolve you from your obligations, and it'll mean you aren't in breach of your obligations under the contract if you don't comply with it. So in terms of facilitating audits and things around that, yes, potentially where that's an obligation on you, it won't serve to undercut something like if you're providing reasonable notice under the contract, or anything that you're actively going to do, because it's about relief from obligations that are on you in most instances. Again, it'll turn on how the clause is actually drafted, but I think that kind of shows there still is a lot of uncertainty around it. So definitely I dig out the contracts that you're looking at and have a really careful read through that force majeure provision.
Yeah, I might just take one last question, then we might sign off, I think, because we've probably gone on a good bit. It's just one question which just said, you mentioned a cap on liability, but the position is unsure. What does that mean? So what I was talking about there is, if you decide, and we've had clients approach us before, and they've been looking at trying to exit from a contract because it's just not working out for them, and they know that they are going to be in breach, and it'll be either an abandonment or a deliberate breach of the contract. And the question that arises is, in that circumstance, if we have a cap on liability, are we entitled to the benefit of it, even though we've deliberately breached or abandoned the contract? And what I was saying is the position is unsure. So I'm not aware of any case law in Ireland on this point, but there is some conflicting case law in the UK in one circumstance where a particular exclusion could be relied upon in the context of a deliberate breach. But in another case, a different conclusion was reached with a similar enough worded exclusion clause. So sometimes what you'll see in a contract now, certainly when I'm acting on the customer side, I'll say that one of the areas for which liability is unlimited is where there's been an abandonment or deliberate breach of provisions of the agreement. But where that's not said, and a party does deliberately breach the contract, there is some uncertainty as to whether they will get the benefit of a cap on liability or not.
Yeah. Okay, I think that probably brings us to a close. Just to say to everyone, thanks for obviously joining. It's been really good. I think we're all kind of struggling with new ways of connecting with people and doing things like that. So hopefully all the technical aspects went okay on your end, and the dog barking wasn't too much of a distraction from the force majeure talk. Just to say, you will get a recording of the webinar following the event, and you'll also get a copy of the slides we had. And you get an email link to a quick survey. So that's pretty much it for us, I think. So thanks very much, Rob, and we'll leave it there.
Great. Thanks, everyone.